we're only at the submission of documents, and we have quite a few other subjects to cover. Yes,
Yes, Your Honor, Madam Chair. I just want to point out that indeed the COMELEC cannot act and should never act anymore on initiative. Patay na ang initiative sa ngayon kasi as stated by the Honorable Chair, there is already an injunction made by the Supreme Court. As a matter of fact, the Supreme Court said the COMELEC is permanently enjoined. Very clear ang sabi ng Supreme Court sa Santiago case. COMELEC should be permanently enjoined from entertaining or taking cognizance of any petition for initiative on amendments of the Constitution until a sufficient law had been validly enacted. To date, there is no valid law that has been enacted. Therefore, any act of the COMELEC on matters pertaining to initiative, even a review of old rules or regulations, should not be made. That will be ultra vires, that will be unauthorized, because there is a permanent injunction. Now, there is also this matter of right to privacy by some contributors or supporters of the initiative. I think the right to privacy cannot be invoked by these supporters or contributors because they have signed as part of the initiative. They were proponents, they were contributors. And what did they state in the proposition that they have signed? They stated, among others, that we fully understand the proposition which were explained to us in our own dialect, and we are aware of its advantages as well as its consequences and effects, as we have read the full text and context thereof. Therefore, if the matter of if they would be asked to reveal their names as contributors, then they could not escape that particular liability because they themselves admitted that they are well aware of the consequences and effects of signing a petition for this initiative. Kaya itong initiative, siguro pwede nagilibing sa limot muna sapagkat marami pang dapat na ayusin ang ating mga mababatas.
Thank you very much, Attorney Mac, for reminding us that in fact an injunction is contained in the Santiago ruling, which we should honor to the present day. Yes, Attorney Abisado, what was that?
Just a very quick reply from Pirma, Madam Chair, with all due respect to my idol, Attorney Rolmy Macalintal, and also the good chairman and the commissioners of the COMELEC. It is Pirma's constitutional right to push for people's initiative. Not even the COMELEC, with all due respect, can kill that right. And the persons, our contributors, are not proponents. So they are not covered by the signature form that was read by Attorney Macalintal. Yun lang po, maraming salamat.
Madam Chair.
Yes, Senator Risa, please.
Thank you, Madam Chair. Further to Attorney Macalintal's point, donors should reveal themselves. Unless talagang iba ang funder, unless iba yung tigapirma. So, just for the record, Madam Chair. May I continue my questions to Chair Garcia?
I would also like to offer the Senate's protection through an executive session, perhaps, or even a witness protection possibility. We have done this before for whistleblowers and such, and we are perfectly happy to do the same for your donors.
Madam Chair, thank you. May I continue my questions to Chair Garcia? Yes, Madam Chair.
The question is not mission of documents. Can we carry on later?
Yes, Madam Chair. Thank you.
Okay, thank you very much. I'd just like to put this aside. We thank the SEC, your representatives are here, I believe, and we are given to understand that in fact, PIRMA no longer exists as of February 10, 2004, is that correct?
Yes, Madam Chair. Your certificate of registration has been revoked since February 10, 2004.
So, when was this in fact registered?
The PIRMA was registered or incorporated on March 12, 1997, Madam Chair.
So from 1997 to to the date that you revoked their incorporation in 2004,